Good morning, Remax Distinctive. It's Dan Bouchard. Hope you're doing well today. We are going to discuss a case that I'm familiar with. I don't know all the details, but I've asked the agent involved, the broker involved, to give me some additional insight. If I get that additional insight, I'll be able to pass it on to you. I know her personally, and I just want to. It's probably she's an excellent broker, and she's very knowledgeable. She's very proactive. She's a good broker. I think she just maybe made a mistake on this situation, and she ended up paying the penalty for it. So let's dive into it. Sandra Y. Stewart, a licensed real estate broker affiliated with HomeSmart, faced disciplinary action. She's now faced with HomeSmart. She was with Coldwell Banker. Faced disciplinary action from the Maryland Real Estate Commission case, yada, yada, yada. The case stemmed from an incident in October of 2018 when Stewart was serving as a branch manager for Coldwell Banker Realty. During this time, Glenn Bonner, a licensed real estate salesperson registered with her office, prepared an offer for buyers to purchase a property located at 9624 Stewart Lane in Clinton, Maryland. However, Bonner failed to ensure that the buyers received the required residential property disclosure statement from the seller. Even the buyers requested it. Even after the buyers requested it. The Real Estate Commission alleged that Stewart, as the branch office manager, so she basically has my role, failed to exercise reasonable and adequate supervision over Bonner's activities as required under the Real Estate Brokers Act. Specifically, the commission cited the violation of the requirement for the branch office managers to supervise the provision of real estate brokerage services by sales agents and associate brokers registered with their office. And additionally, that allows the commission to reprimand, suspend, or revoke a licensed branch manager for fails to provide supervision. So to address these allegations, the Real Estate Commission issued a statement of charges in order for a hearing on April 30th, 2024. The scheduled hearing was for September in 2024. However, Stewart opted to resolve the matter through a consent order and settle the agreement to avoid litigation. Terms of the settlement agreement. So the admission of violation, Stewart consented to the finding that she violated the Brokers Act though she did not admit any wrongdoing. The reprimand is permanently on her record. She received a civil penalty of $1,750 to be paid within 30 days of the agreement. She had to go through some additional continuing education requirements. If she did not pay the fine, she would have been suspended automatically until the fine was paid. And Stewart waived her rights to an administrative hearing, further proceedings, and appeals. So the resolution, the Real Estate Commission accepted that whole situation, that remedy. She ended up paying the fine. Her license was never suspended, and she took her continuing education and continues on. So it's important to understand the case that highlights the importance of the branch office managers ensuring compliance with the real estate regulations and adequately supervising their staff to avoid legal and professional consequences. Dan, I know this associate broker personally. She's an excellent and conscientious associate broker, educator. She teaches for GCAR and a manager as well. The foundation of the case and reprimand was based on the fact that the file review process she used omitted the verification that the disclosure was in the file, and that the file was issued an agent payout with the document still missing from the file. So this is why I am so diligent about the compliance stuff, because at the end of the day, it's a matter of protecting your license, my license, Andrew's license, and all of our wallets as well. So I have a vested interest in making sure that your files are in compliance, because as you can see here, I can see how I believe that what happened in this case is that they use a similar system like we use for SkySlope, and apparently either the document was never in the file, or it was never added, and it was subsequently the agent got paid for the transaction. And so this is why we can't issue payment when we have required or needed forms like this that are required for the transactions. So just wanted to bring it open for a discussion for DC. You know, DC, you know, it's a deep well of regulations and requirements. Kevin and I were just talking about rentals. It's even worse with rentals. But anybody have any thoughts on this scenario that we just discussed?
Was that DC or Maryland?
Yeah.
I'm sorry, that was Maryland. That was Maryland. Yeah, yeah.
Oh, okay. But does
Same,
that
but
go on the Maryland depot then as a
yeah,
like a reprimand on her license?
yeah, that was a reprimand on her license for Maryland depot. Yep.
So if somebody looks that up, they'll see it as a flag. Like,
Oh yeah, all of these cases that I do like this are all public, with the exception of the DC case. DC's cases are not public knowledge, public information, but Virginia cases and the Maryland cases are public information, and all of these cases are
but
real. They're real cases that are
and
that are
she's still allowed to
public.
be a teacher getting
Huh?
cited like that. She's still allowed to be an educator after getting cited.
Yeah, yeah. She made an innocent mistake. I think it was probably an oversight. She might have clicked the file approved when it really shouldn't have been. It might have been an innocent mistake. I have made innocent mistakes like that in the past myself. The problem is she just got caught. Yeah. I mean, the real estate commission understands that we're all human. But they have to hold us accountable.
I
So,
think her
Mhm.
accomplishments probably outweighed her one mistake.
yeah, yeah.
I know her too. She's always seemed like an excellent.
Yeah, she's very thorough. It surprises me that this came up against her because she is so thorough. But this is why I'm such a stickler about this stuff, because I don't want your actions affecting my wallet or my
Who
license.
reported her on that? Who reported that? The buyer?
I don't know. The case doesn't
Doesn't
say.
it say who made the claim on this?
No,
Like
no,
who files it?
no, because here's the case. Here's the actual case. This is the actual order on it. Wait, it doesn't usually these complaints don't. The complainant is the real estate commission. I believe in this particular case there was a complainant that raised the issue that brought it to her attention. And I even suspect that it might have even got, because there is a mention of litigation in the
Yeah.
course in this thing. So it's probably the buyer whoever
Yeah.
bought 9624 Stewart Lane in Clinton probably sued her, and
Hmm.
and as a result of the lawsuit probably ended up being filed with the real estate commission. So she may have even paid some fines through the lawsuit and then got a double whammy on it, probably with the real estate commission.
Well, Dan, what
So
about like I know some people in Maryland will do more of a full disclosure, but I still think a lot of people use disclaimer like Virginia. But
yeah,
I've always understood it, at least in Virginia, and I don't know for a fact this in Maryland, but if you don't like at any point in time, if you're a buyer in Virginia, and I'm not because I don't know, you can clarify in Maryland if it's the same or not. But in Virginia, I was always told if you don't have a residential property disclosure provided by the seller, at any point in time, you can send notice voiding the contract in Virginia going, I wasn't provided this disclosure disclaimer, I'm voiding the contract. And
and in
maybe we could even
DC
look at that.
and in DC and in Maryland that also applies.
So in the funny thing is sometimes a buyer's agent doesn't want the listing agent to provide it, actively provide it, because it allows them a way out of the deal.
Yeah, yeah.
I mean, to me, it's a
Um,
strategy. If you think there's like kind of the house is iffy or people are playing games, you go, oh, you didn't provide that. And then I don't even know if, like, when you hang the documents, I would assume that means you've provided it, like if it's part of the documents that you've uploaded.
yeah, yeah. As long as you've uploaded it. Well,
Yeah.
no, no, I mean, you actually have to include it in the transaction. So, I mean,
Well, right, as you're ratifying or something. So a good
yeah,
listing agent should say, hey, you forgot to sign this.
right.
Yeah.
But this is
But
why I want to make sure that everybody understands that, this is why we're pretty we're pretty specific about these things because we don't want to get nailed. We don't want you to get nailed, and we don't want to get nailed. So,
What if we weren't provided with it? So this brings up good question in a weird way. What if we weren't provided with it? We disclosed it in writing to our buyer and said, by the way, this document wasn't provided. I wanted to let you know. Do you want to proceed with the transaction without it and ratify the contract? Because if we do ratify the contract and maybe down the road, this is still not a provided document, it would allow you to void the contract. Like,
I
what if
think
we
you
did
would
all
be,
that in writing?
I think you'd be probably covered with that. If you were the buyer's agent, I think you would probably be
Right.
covered with that. Now, if you're
Yeah.
the listing agent, I wouldn't, that would not be acceptable.
No, understood. Yeah. But on the
Yeah,
buy side, I mean,
yeah,
it's like a contingency for us that if they're not going to provide it, you know,
yeah.
I mean,
But what,
I don't want a deal to blow up. So I
and,
probably wouldn't do that very
and
often,
in a
but still.
case, and in a case like that, if you're the buyer's agent and the listing agent won't provide a document, I need to see evidence that you asked for it. Like, send me a copy of the email that you asked for it, and their response saying they wouldn't send it. We're not going to send it. We don't have it. I need you.
But that's the
I need to
question.
see, huh?
Do we want to ask for it? What if it's just not provided? Why do we want to ask for it? It
Because we
protects our
want
buyer
to.
if we don't ask for it.
As
Well,
the buyer's
it
agent.
just covers everybody's bases.
Well,
It is a way to prevent the lawsuits from happening. It's not necessarily a
yeah,
way for us to defend ourselves, but let's prevent the lawsuit from happening to begin with. And so
right.
if we have that, that can go a long way towards preventing the lawsuit to begin with.
And I'll interject here too, guys, that, with me living in Maryland and working in Maryland real estate for going on 21 years now, I have never had any either buyer or seller side had a problem with this. It's always there when I ask for disclosures. I've never seen anyone withhold it on purpose. I've certainly never not made sure I didn't get that signed when I'm doing a listing agreement. This is surprising to me that this even happened because I've never seen this, and I've never seen anybody use it as, like Kevin's saying, a kind of a silent contingency to get out. I've never seen that happen. So this is surprising that there's a
It's
debate about whether this should or should not be done. It's
yeah.
yeah, I've never
It's
seen it.
extremely rare. It is extremely rare. And I'll tell you, I have actually just in the last 2 years since I've been with the company, I don't know, actually, I think it's been more than 2 years now. And reviewing the files for the company, I've actually seen it like two times, a similar situation to this 2 times happen in the last 2 years. Just from files that have come across our desk. I think I believe, if I'm not mistaken, both of the cases were our buyer agent, and it was the listing agent on another side that was being the problem. So yeah, it happens. But it is, Kathy's right. It is very rare.
In the MAR forms, is the disclosure like it is in DC where it's the seller fills it out in detail, or is it more like Virginia?
It's a combination of both. So it's a combination of both. So you have the option in Maryland, you have the option to fill out the entire disclosure. It's a shorter, the disclosure itself is shorter than DC's, but it's still there. So it's a two-part disclosure. You either fill out the first part or the second part. You don't fill out both parts. So the first part is the full disclosure. The seller signs it, buyer confirms it, and then that's the end of the deal. I will accept that in the compliance file in SkySlope. Or the second part of it can be signed as a disclaimer, and I will accept that also. So you don't sign both sections, you simply sign the first section, and it's all on the same document in Maryland. Whereas in DC, you don't have the option to disclaim. It must be disclosed. And if you don't answer all the questions in DC, the disclosure, like Kevin mentioned earlier, it gives you the right to back out of the contract. And if you don't sign the disclaimer, in Virginia as well. That's also, they call it, we're not supposed to call it a disclaimer in Virginia, even though that's really what it is. But I don't, anyways, we're not supposed to call it that. It's a disclosure disclaimer.
And Mel, if you wanted to know, it's 3 pages for the disclosure, as Dan would tell you. And of course, the disclaimer is just a short, almost like a half page.
Yeah.
It just asked about latent defects. But Dan, you can chime in your experience, but my experience here in Maryland, I would say the majority always disclaims rather than discloses. We do see some disclosures, but a lot of it is disclaimers. And again, Dan, you jump in, but the theory when you talk to other agents is that if there's a mistake on the disclosure, an inaccuracy, there is a concern that that could lead to legal actions. And explaining both options to your seller, a lot of them will just choose to disclaim rather than disclose and stay out of the
And I have
attention.
heard that argument from a title attorney in Maryland
Mhm.
as well, who actually does recommend that. And the reason why he recommends that is because he's trying to prevent a lawsuit from even beginning.
Mhm.
In the end, I think if you provide a disclosure and there's a mistake on it, I think in the end you're likely to prevail if it was an innocent and an unintentional mistake. And I think there's a lot of clarity in case law that says that you will prevail in a case like that. But if you so his objective is to prevent your lawsuits from happening to begin with. Just use the disclaimer. I kind of look at it a little differently. Yes, I think that that's probably true, but I am always an advocate for disclosure because disclosure insulates you from being ultimately held liable. And while the disclosure may not prevent a lawsuit from occurring, it may very well protect you in the end, and it protects your seller. And I think the chance of protecting you is greater by doing a full disclosure and perhaps making an accident on it than using a disclaimer and simply trying to claim, like, for example, a good example of the disclaimer where a disclaimer argument wouldn't work for you is if you disclaim material knowledge of a property in Maryland, of any defect in Maryland. And I'll use the example of the Superfund sites, right? The law in Maryland specifically requires the seller to disclose the presence of the property within 1 mile radius of a Superfund site. And there are Superfund sites in Maryland. And if the seller if the seller doesn't verify their address with the website for Maryland on the Superfund sites, and they check the box and simply say, no, I'm not near it, when in fact they really are, I think they could be liable. So it's better to disclose it and verify it than to not disclose it and to try to claim that you're exempting your knowledge of anything like that and be sued for it and then probably lose that. Because I think
Dan, I've never heard that. Like another lookup that the seller or you as a listing agent have to do. And all the education I've heard, I've never heard about
Yep.
Superfund site
Yeah,
lookups.
absolutely. That's why
Because we
it's
have all this stuff where we have to provide tax bills, estimated tax bills, like
well, that's wait.
subdivision
Now,
plats, all that stuff.
okay,
But
wait. Okay,
yeah,
wait. So we're mixing apples and oranges here. The subdivision plat stuff is only issued, that's only part of Montgomery County.
right.
But the Superfund site is applicable everywhere in Maryland.
What is a
Yeah,
Superfund site?
It's
toxic
chemicals in the
waste.
ground.
Toxic waste in the ground, and federal government has determined that certain locations are Superfund sites, and Maryland law says that the landlord, the owner of the property, must disclose their location if they are within 1 mile. And that's absolutely true.
Is that on a Virginia jurisdiction, Montgomery jurisdictional addendum or something?
No,
Montgomery County? I've never seen that.
it's in the listing agreement in paragraph 31 of the listing agreement. For Maryland, in the Maryland listing contract, it's part of the requirement there. In the G-Car sales contract, it is not present in the G-Car sales contract. But you're still required to disclose it if you are located within the site, within that. So
Uh,
G-Car needs to fix their listing agreement because it's not included in the G-Car listing
well, can
agreement.
you mention that to them? Because I've never seen this. And like you bring it up, and I'm like, okay, well, I never looked up an address in a Superfund site, and I'm pretty careful
Well,
if
you
I know
don't.
we have to do it.
It's important that you don't look it up because if you look it up and determine that it's a response, the law says it's the responsibility of the owner. If you are going to do it for your owner, you are assuming liability for the correction of it. If your owner does it, the liability remains with them.
Well, I would think though, since it's not in the G-Car contract, like on the
No,
jurisdictional, it has every possible thing in there. And it's probably like has like on a buyer beware, right? It probably says here in jurisdictional, it says here's where the airports are, here's
no,
where this is, here's where this. So I think it probably says like
no, it
to
doesn't.
buyers, they
Trust me.
need to check it.
I'm
No?
on I'm on the forms committee. I
Well,
know
when the wire to form's inaccurate, then why would we have G-Car forms that don't say you have to do it?
it's a mistake and
Yeah.
it's in the process of being corrected. Yeah.
Okay. Well, that's
Yeah.
like that
Yeah.
seems
I
to be
mean,
a huge mistake.
it is. You're right. It is. Absolutely. Absolutely.
Yeah. This is why like if we all had like more, like the fact that all these counties have different forms and that, one county like in Maryland has one form and Montgomery County has their form and like they should have one form. Like all in Northern Virginia we use one form. The different counties don't have different forms.
Mhm. I
I
hear
mean,
you, and what you're saying makes a lot of sense. This when you're talking about it's like Meg Burke likes to talk about. Meg Burke despises Northern Virginia Association of Realtors, right? And
that's only because she's a board member on DAR.
no, exactly. But all of the point that I'm making is that all of these associations fight each other and they want the people who like GCAR prefer GCAR contract. They don't want to see an MAR contract. The people who are in MAR jurisdictions prefer the MAR contract. They don't want to see a GCAR contract. So and they all fight each other. All of these associations fight each other and they don't collaborate a lot. And that's a turf war that's above our pay grade. And that's something that should be taken up with the boards of directors of all of these associations. But that's above our pay
Well,
grade, so
The Maryland Association of Realtors should fix it, not you or I.
yeah.
But
So so well, the forms are the associations that fix the forms. The so Maryland Realtors will fix the Maryland Realtors forms. GCAR will fix the GCAR's forms. NVAR, VAR, Virginia Realtors, whichever one it is, they have to control their own forms. So that's just the way that it goes. We don't play the decision making in it. We just have to follow their rules. All right. Anybody else have any thoughts or comments on the disclosures and checklists and things like that?
Well, I was just going to say too that Kevin, on the listing agreement in the MAR contract, it also does require the seller to say in that listing agreement, it does bring up the super fund there.
Yes,
So
and
yeah,
that's in paragraph 31 of the listing agreement.
yes.
right, but
Yeah,
I
so
don't
that,
use MAR stuff. I have MAR forms,
oh,
but I
you
don't
only
use
do
them unless I'm
G-Car?
in a county. Huh?
Okay, so you only work in Montgomery County then when you're in Maryland?
Well, no, I've used them if I go. It's just the same as like I had to use VAR forms because I was down near Charlottesville once, and I'm like, these
Mhm.
forms suck. Like sorry, pardon the French, but the yeah, I tend to really like the way GCAR and NVAR forms are, and so I try my best not to. I'm kind of at the point where like I don't want to just complicate my life with learning new forms.
Well, just remember, if you're going anywhere outside of Montgomery County, you cannot use GCAR forms.
Yeah, that's why I asked, because we
What
have
about
agents
Prince?
here that will say in their agent remarks, must use MAR forms when you're outside of Montgomery County. So like, for instance, if I'm writing something, an offer or a listing agreement, well, it'd be an offer
In
for Anne
Annapolis?
Arundel or,
Yeah.
or Prince George's or Howard or whatever, they're not going to take a GCAR form. They're going to tell me do a MAR, and they will also, frankly, silently judge me if I tried to use a GCAR form in any of those counties. So yeah, it's kind of funny, but like Dan said, it's a click. And I mean, my affiliation is GCAR. So I had to know both GCAR and MAR contracts since I'm mostly all Maryland now.
I've used them, but it's the same in like Virginia, right? Like if you read a VAR contract versus NVAR contract, I mean, there's language differences. There's even like different rules, like per contract. I mean, the rules should be the same, but I don't think they all are.
Yeah. Well, there's differences. And like I said, that's why, for instance, the realtors that are in other parts of Maryland other than Montgomery County insist on the MAR forms,
Yeah,
because as you said, some of them just really learn just that if they're not working in Montgomery,
right.
and they have the prejudice that they have about
Yeah.
GCAR, like Dan was saying, and vice versa. So, but I
Mhm.
will say, in the more seasoned agents in Maryland, if you are not, if the property that you're writing an offer for is not in Montgomery County and you produce a GCAR form, they will come at you for that.
Well,
And they will silently judge you a little bit too.
and
Yeah.
in addition to that, more to the point that you should be concerned with is the fact that if you use a GCAR form in Prince George's County, for example, if you use a GCAR contract in Prince George's County or Anne Arundel, I don't care which jurisdiction, and an issue comes up in at some point later on that is not addressed in the GCAR contract that was addressed in the Maryland contract, and the liability is determined in a court action or by the real estate commission that you use the wrong form, you could be held liable for using the wrong forms, because GCAR does not authorize the use of the GCAR sales contract in other counties except for Montgomery. So you must only use the GCAR sales contract in Montgomery County. Or DC, Montgomery County or DC.
Mhm.
Yeah.
Yep. And there's
Mhm.
no waiver, and your liability, you could be held liable if it were ever to go to court or something, or if you had to make a judgment or something or whatever, you could be held liable for using the wrong form. So it's important. Keep your jurisdictions, if it's not Montgomery County, use Maryland Realtors contract.
This means call Kathy with questions.
Yeah, and or referrals, Kevin. Don't be greedy.
Yeah, I
You can
know. I
throw them
like
this way.
Annapolis though. I like Annapolis. I want to drive there.
Well, you can come have lunch with me over here. That's fine.
I might do that. Yeah.
Yeah,
She's
yeah,
like, give me your business.
yes.
We're gonna
You
All right.
if
have enough.
if I yeah, we're gonna have to change our referral fees then.
Well, we'll have a conversation over lunch. You can buy. This works out great.